same was also established in the case of Rohit Pandey versus the Union of India as well, Your Lordship. 1.2, issue 1.2 deals with the violation of the right to privacy, Your Lordship. So as we know, privacy is a particular right that's embodied in Article 21 of the Nigerian Constitution, which speaks that privacy is not an absolute right. It can be fettered, but only through the means of due process of law or due procedure of law. Now, how due procedure of law is interpreted is that the law must be reasonable and justiciable in nature. It must pass the test of Article 14, 19 and 21, Your Lordship. And the same is not seen in this particular instance because first of all, there exists no due process of law in the first place to entail as to how this particular software can be used or can be used to infiltrate into people's devices, Your Lordship. Secondly, there seems to be no rational nexus between the aim of the software and the particular aim that it seeks to achieve. You are using a software to infiltrate into people's devices and invade their privacy. However, the reason for such an invasion is not given. The grounds, whether they are constitutional or not, are very unknown in nature, and there is an arbitrary amount of hacking into several eminent portfolios of individuals, Your Lordship. In the case of PUCL versus the Union of India, the court established a particular set of guidelines with regards to how interception should take place and how that particular and what are the particular legislations that could be concerned with it. And one of the particular rules that they stated in their guidelines was that before an interception is made, it must be made with a warrant from a judicial officer, from the judiciary. This is because when a huge amount of power is vested in the hands of the executive, especially an act such as infringement of privacy, and when this particular act is not governed, is not checked, is not balanced with any form of other power to look into it, it will result ultimately in the arbitrary usage of it, Your Lordship.
69 of the IPA. 69 of the IPA.
Yes, Your Lordship.
Do you not apply to this spyware also?
No, Your Lordship, because 69 talks about only the monitoring and decryption, Your Lordship, but this software possesses another additional factor. It can also manipulate the data. It can put forth new data of its own, delete the data that exists within the device, Your Lordship. These are not something that mechanisms...
So do we take it that your objections only as regards
manipulation alone, not regarding interception or gathering information,
only manipulation alone?
The council is not objecting any form of interception or monitoring as long as it is done in the grounds that have been provided in the same act, Your Lordship. So even if in this particular case, Meluha has used this particular spyware and they have intercepted and monitored, that would still be unlawful if they do not possess the constitutional grounds to do so, if their intentions were malified in nature, Your Lordship. So it is not about the act itself, it is rather...
Now you are coming down to the exercise of power. You concede that there is power, but the exercise of power is bad. It is distinct from saying that there is no power.
Yes, Your Lordship. The same was established in the case of Manohar Lal Sharma versus the Union of India as well, Your Lordship. A very similar case that talks about the spyware known as Pegasus, and the court had established an inquiry committee in that case, and it had also stated, the court itself had stated that neither parties, the petitioners itself, are not contending that the spyware mustn't be used. It is just that the spyware must be used only in adherence with the constitutional grounds, Your Lordship. And here there exists a huge amount of discrepancy as to what the usage was.
In Sharma's case, the finding is that such a spyware was not found in the file samples. Therefore, the committee is appointed. Understand? So forget the ill effects of it. Very spyware that the petitioners were claiming were not found in the 5 samples. That is when the apex court said that we are unable to take a decision on any of these things, and that report is not made public. We are not in a position to understand what else was there in the form of that. So forget all these things. When the very spyware itself is not found, where is the question of manipulation thereof?
Your Lordship,
So therefore, it's all imaginary. No court can grant any relief on an imaginary issue. Man suffers more in imagination than in reality. We are unable to find from the facts what manipulation, no data. I think we will dispense with this. That might be better. I think I am audible to the all in the last.
Your Lordship,
Even they say
council is not...
both things cannot work.
Your Lordship,
Manipulation with the sound is
Well said, brother.
Your Lordship, counsel is not disputing the particular facts of that case, Your Lordship.
Right. Probably you have given the time, you can restrict to the reasonable restriction and exercise of the power by
I want to put a question. This listen this question and answer.
Yes, Your Lordship.
The question based on the question you now raised. The question is, nowadays I have noticed that some of the high courts in this case is closed. Because the condition the way they teach the short form, the GPS that so that the executive or the policeman can place and what are the actions these boys will done during the period of the day. Whether it amounts to right and privacy. It's an ancillary question connected. Can a court impose a condition